Hello, everyone. Thank you for joining us for the April edition of Michigan PIP Monthly. This is a Seacrest Wardle podcast that is launched every month, and we discuss various topics and trends in the no-fault arena, specifically pertaining to first-party practice. We also provide you with an overview of what's gone on in the courts for the month so that you can handle either your claims or your cases or work with counsel with these new cases in mind, so you can have the most current defense plan in place when you are looking at these first-party actions. As you know, my name is Javon David. I'm a partner in our Troy office. Today we're doing things a little different than what we've normally done with the podcast. I have my partner Renee Townsend here. She's also in our Troy office. And Renee is going to discuss some recent strategies that she's been successful with pertaining to reptile theory. The reptile topic was one that was discussed last month, and we had a lot of interest from a lot of our carriers about the reptile theory specifically, and had some more questions about how it actually plays out in trial. So we'll talk about the reptile theory continued, defeating the reptile theory at trial. Renee will talk about a recent success with her trial victory in Wayne County Circuit Court, where the plaintiff attorney did, in fact, use a lot of the reptile tactics that we talked about last month. Once we discuss her spin on the reptile theory and her experiences, I'll go through some of the Court of Appeals case law, the Baker case, the Bronson Methodist case, and the Hernandez case that came down this month. So before we get into the specifics of the trial tactics and reptile theory, I'll go through what we've talked about the last month or so for those of you who missed it. The reptile theory is a part of practice that has the goal of structuring a case in a way that switches a juror's brain into survival mode when he or she is deciding a case. So rather than deciding the case on logic and admissible evidence, plaintiff attorneys will want the jury to place themselves in the position of the insured and feel threatened regarding a potential risk of harm. So as a result, the jurors will find themselves asking, could this happen to me? What if I was the plaintiff in this case, then they weren't paying my benefits? And really start to sympathize on a much deeper level and a much more innate net level than they normally would. And they don't focus on whether or not the plaintiff was actually harmed, but instead they focus on the emotional response that was evoked by the plaintiff attorney. So, Renee, sitting here with me, you recently had a trial in which the reptile theory was used, so you can go through all of that.
Yes, Javon, thank you for having me on the podcast to talk about the trial and kind of the practical implications of the reptile theory. Like you mentioned, it's just a way that the plaintiff's bar has developed to ask a jury to set aside their reasoning and set aside logic, set aside the facts of the case, and just make their decision based on emotion. And if it's executed properly and in the way it's intended to, they do that without even realizing that that's what the jury does, that without even realizing that's what they're doing. That's exactly what the plaintiff's counsel tried to do in a trial that I had last month in March in front of Judge Dan Hathaway in Wayne County Circuit Court. In that case, it was a PIP case. There was a UM count as well. I ended up getting a no cause on both counts, despite the plaintiff's counsel using that tactic at trial and specifically in his closing argument. So the things that I kind of wanted to touch on the podcast today is just how you recognize that strategy is being set up, how you combat it before you get to trial and start to set up your defenses to it, and then what to do when it comes up during trial.
So did the plaintiff attorney in your case kind of tee up his files with the reptile theory throughout, or was this something that he resorted to at trial?
He teed it up a little bit, specifically at the discovery deposition of the adjuster. He started questioning her in a way that focused more on general claims handling instead of focusing on the specific facts of this case. And that's one way to get to the reptile theory, so that you can establish for the jury a general claims handling process that they can then apply with their reptile brain to all claims versus what happened in this specific claim. So one way to combat that in a pretrial sense is at those depositions, make sure that you get the testimony that you need, or your attorney gets the testimony that they need to elicit the facts of this case, why decisions were made in a certain way on this case, and not just general hypotheticals.
And the podcast last month actually centered more on the deposition setting that Renee's speaking of at now. And, you see that the plaintiff attorneys will put this into practice by asking, very, very general questions. For example, do you believe that an insurance company is required to promptly and fairly investigate a claim? Does the insurance company always have to look for evidence for coverage? Do you think that the insurance company should act with the best interest of the claimant in mind? These are all questions that they're using to tee you up to pigeonhole your answer so that if you say unequivocally yes or no, you ultimately have to agree with them when, it comes to the decision making that was behind the denial of a particular claim. So just bear in mind that, we're talking about trial today, but the reptile theory can truly be rooted from the pretrial portion, beginning with early written discovery and going all the way to the discovery depositions of any adjusters.
Yeah, and it continues into the testimony that they get from all kinds of people, whether it's your medical experts or your liability experts. They'll ask during either discovery depositions or trial depositions of medical doctors, kind of general treatment plans, whether certain treatment would be reasonable, instead of emphasizing the facts of the case and why certain treatment was unreasonable in the specific case. It's even more prevalent when you're looking at a liability expert like a biomechanical engineer or someone like that, because the plaintiff's counsel will then discuss kind of safety rules and why the safety rules are important for a community. Why do we have stop signs? Why do we have lines on the road? Is it important for people to follow the rules? What you need to do to combat that is bring it back to the facts of the case. And then also circle back to say that there was no violation of a safety rule in whatever case you're dealing with. There was no threat to the community, so you can kind of untrigger that trigger that was switched. If you're kind of talking more too, Javon, about pretrial things that you can do pre-trial to combat the reptile theory being used at trial, a good way to do that is with a motion in limine. I don't know if you talked about that on your last podcast.
Yeah, that was discussed, but whatever insight you have would be invaluable.
Yeah, so just kind of generally, you file motions in limine to preclude evidence or strategies being used at trial, certain buzzwords being used at trial. So if you file a motion in limine that just says you want the plaintiff to be precluded from using reptile theory at trial, the judge is not going to even really know what you're talking about, and most of the time they're just going to say, let's just see what happens at trial and deny your motion without prejudice or just deny it outright. Instead, if you file a specific motion in limine that says that a plaintiff cannot use certain terms until proofs have been submitted that support those terms, that would be more likely to be granted, and then keep out that reptile strategy. So, for example, if you anticipate the plaintiff's counsel is going to try to assert that your company or your client was unreasonable or somehow they caused a hazard, what you want to do is make sure they can't use the word unreasonable and they can't use the word hazard until they've established either that the company or the defendant was unreasonable in some way via testimony or other evidence, or that a hazard was actually in place. They can't just blanket assert that to kind of, again, trigger that reptile brain.
So how did the judge in Wayne County, in your case, handle any kind of objections in that regard? Were they receptive to it? He
was receptive when it was specific, and that's kind of my point. You have to be very specific and not just give blanket objections that say, he's inflaming the jury or anything like that. It's got to be, there have been no proof submitted so far to show that there was an unreasonable denial of benefits, those kinds of arguments. And that's when the judge was receptive. But more so during trial is when these things kind of come up on the fly, because when you start trial, you really never know where the plaintiff's counsel is going to go. You have some idea because we start to submit things like voir dire questions for the judge to approve, but you don't know what he's going to say in his opening statement. You don't know what he's going to say in his closing. So you have to kind of be ready to look for those things and be prepared to respond to them. So in our case, it came up several times. It came up in the voir dire, it came up in the opening statement, it came up in cross-examination, but the biggest place that it came up was in the closing the plaintiff made. And I think that closing, my response to that closing was really kind of a key element in getting the no cause. But let's just quickly review the other ways that he used the reptile theory to kind of set up the jury for that closing.
From the beginning of the trial?
Yes, from the beginning. So in the voir dire questions, the plaintiff plaintiff's counsel began priming the jury for the idea that somehow the defendant endangered the community. So themes were set up in the voir dire questioning, such as community standards. Is it important to keep a promise? There was a question about that. And I will say the jury was a little bit confused by that specific voir dire question and basically said, well, I guess it depends on the circumstances. But instead of just getting up there and not addressing that, I responded to it by giving more detail. Is it important for a party to keep a promise? Is it important for both parties to keep the promise that they've made? And so I set it up to show that there might be a question as to who actually broke the promise in this case, the plaintiff or the defendant.
And from that perspective, arguably the plaintiff broke the promise to submit reasonable proof or to submit the right documentation as requested or their medical records. Ultimately, that's where you went with that.
Yeah, and that's exactly what happened. I made it clear in my voir dire questioning that there were things the plaintiff was supposed to do that she did not do. And there were also other kind of reptile questions from my end that turned it around. So should an insurance company, do you believe an insurance company should pay any claim that's submitted to it, no matter if there's proof or not of an injury or an accident? And so that kind of starts getting the reptile theory to be used on our side and gets the jury to think from the defense side with their reptile brain.
Now, did you tell the jury at any point this attorney is using this strategy, or did you just address it by attacking what he already had said?
So that's where it came into play in a big way in the closing argument. That's exactly what I did. Was I just called it out. The plaintiff's counsel got up and he gave his closing. He set up kind of a good guy versus bad guy theme, saying the plaintiff was a homemaker who recently immigrated to the United States for the American dream that became a nightmare, and that the insurance company defendant had a playbook, and he physically pulled out a book that he had written on the front of it and said it was called Delay, Deny, Defend by Dewey, Cheatham, and Howe, and said that the adjuster would look to this book, and there's a chapter in there on EUOs, there's a chapter in there on IMEs, there's a chapter in delaying payment, there's a chapter on refusing payment. And from there he went into an argument that really triggered the reptile theory censor, and kind of on my end that he was basically saying, don't let the insurance company do this on this claim, because if they do this on this claim, they're going to be emboldened, and they're going to do it on a claim next week, and then they're going to do it on 2 claims the week after that. They're going to do it on 3 claims, and then all of a sudden you've got thousands of claims that are being denied. You've got people all over your community, in your neighborhoods, having claims being denied because the company knows they can get away with it. And so when it was my turn to get up and respond...
So he was trying to say, if you let them win here, they're just going to keep doing what they're doing, and in his mind that's deny everything.
Yeah, just deny everything and ignoring the facts of the case and asking the jury to ignore the evidence in the case. And so he established kind of a danger to the community in that way, and said that they had the power to improve that danger and to fix that danger by not encouraging the company in finding in their favor. So all I did is I had my prepared remarks, but once he said that, I stood up, and the first thing I said was, I've got some prepared remarks for you, but I first want to talk about what just happened here. And I asked the plaintiff's counsel if I could see the book that he was using. I pointed out how this wasn't a real book that the insurance company had. And then from there, I told them specifically, he is using the reptile brain theory on you right now. What he's doing is something that's written about extensively on the plaintiff's bar, that basically he wants you to forget about everything you've heard in the last 6 days of trial. He wants you to ignore all of the facts and all of the evidence we put before you and just play on your emotion, because he wants you to be angry with the insurance company. And you could tell that once I called it out and told them about what the reptile theory was, explained how it works, explained that it goes back to that deep part of your brain that wants to protect yourself and your community, you could see their faces change. And they really did not appreciate that the plaintiff's counsel was trying to fool them in that way. And they were very receptive to the fact that I called it out and I was honest with them about it.
So the plaintiff attorney didn't object or anything when you were revealing that that's what he was doing, and the judge let you go with that?
Yeah, absolutely. Okay. I mean, I don't know what the objection would be. All I was doing was indicating that, these are the things he said to you, and this is why he said them to you.
Right.
So,
Well, what's interesting about that is while he's trying to play on their emotion and trying to really get at, the sense of having community and safety and all of that, the flip side of that is people don't like to be tricked, and people don't like to be fooled, and they don't want, it's condescending to have this whole playbook where you're really just feeding on their ignorance. And, once that's revealed to the jury, I think that's probably took a big turning point in his strategy.
Yeah, I mean, I think that throughout the case we had a lot of evidence in our favor. I think that we rightfully won the case, but I do think that once I was able to show that the plaintiff's counsel wanted them to ignore the facts and simply decide based on their emotion, they really started to see the difference in the way the cases were presented. And when we pulled the jury after the trial, they basically said the plaintiff did not meet the burden of proof. They stuck to the facts, and it was clear that they appreciated the straightforward nature that we presented our evidence, or in which we presented our evidence, and they didn't appreciate that the plaintiff's counsel was trying to kind of back end his way into their minds.
Okay, so since going through that trial and seeing the reptile theory in action, I guess if you had any kind of tips for the claims handlers at the claim stage, what would you suggest?
Just to keep it in mind in your claim notes, keep it in mind in documenting those kind of big milestones in the case, and making them specific to the case. So don't, I'm sure most of our clients don't do this, because I think that most people understand not to, but you don't want to have kind of a set way that you handle cases. 30 days comes in, I set up an EUO. 90 days comes in, I set up an IME. When you start to handle your claims in a general way, it makes you more susceptible to the reptile theory versus really looking at what claims come in, what the status is on all the evidence and the reasonable proof that you have, and making your decisions based on that and based on your training. I think it's much more difficult for a plaintiff's counsel to get to that reptile brain if you can draw the jury back to the facts of the case. And if you had good claims handling and good documentation of that good claims handling, that's a lot easier to do.
I agree with that completely. It goes, first it starts with just the initial discovery requests and things like that, and they'll ask for things which we can control, but it starts even sooner than that, and it starts with what's in the log notes. And if you remember, as the case goes on, you adjust everything on a case-by-case basis. Nothing is done or should be done in a blanket form. And if you're handling your claims with that mindset, you're really doing yourself and your counsel down the line a service by, having that rock-solid claim notes in place.
Yeah, I agree.
Well, congratulations on your trial, no cause, especially up against, the reptile theory, which not a lot of plaintiff attorneys will implement. It actually takes some skill and some experience to even understand how to do that. And quite frankly, we don't even really see it very often because people botch it up so much on the plaintiff side that it never really gets to that point. So just things to look at, as we've discussed, is recognizing it early and seeing it through all the way through trial.
Yep, I agree. All right, thanks, John.
Thank you. So after we've gone from the reptile theory part of this, and we can focus on some recent case law for claims handling purposes and in your litigated files, as we monitor the Court of Appeals, the Michigan Supreme Court, and all the federal courts to see if anything really noteworthy has come down. And we provide you with all the newest and latest case law in our No Fault Newslines. If you have not subscribed to that, go ahead and contact me or our marketing department, Linda Williamson, and sign up for our newsletters, and you'll get the updates as they come out. And this month, there are a couple of noteworthy cases, particularly pertaining to affirmative defenses, and that's the Baker versus IDS Property Casualty Company case. That case came down early on in the month and particularly pertained to affirmative defenses raised by counsel utilizing their fraud defenses. Fraud, from our legal perspective, is an affirmative defense that is waived if not raised in an answer. That means from the moment that you are filing an answer to the complaint, you need to be pleading fraud, and it has to be raised with specificity. So if there is a fraud investigation in the claims, recognize that early on and be sure that your attorney is including the affirmative defense of fraud in those kinds of cases, otherwise it is waived. And unfortunately, that's what ended up happening in the Baker versus IDS case. In that action, the plaintiff filed suit for first-party benefits and uninsured motorist benefits against IDS after a motor vehicle accident. The defense attorney filed numerous affirmative defenses and did reserve their right to file additional affirmative defenses as they become known during the course of investigation and litigation. However, the affirmative defenses raised did not include a defense that the insurance policy was void ab initio on the basis of fraud. The plaintiff amended their complaint, adding claims against additional parties, and the defense once again failed to raise any kind of contractual claim of fraud as an affirmative defense. Ultimately, throughout the course of discovery, it was determined that there was some fraud in the procurement of the insurance policy, which would make it void ab initio. IDS did not raise the argument that the policy's fraud exclusion clause was applicable. However, they did so in the motion for summary disposition and argued that fraudulent misrepresentations were made that would preclude the entire claim under the fraud preclusion in the policy. Of course, the plaintiff attorney looked and reviewed the affirmative defenses, as they always do if you have a good plaintiff attorney, and they argued that, hey, you can't argue that this is fraud because you never raised it as an affirmative defense. And it's important to do that because early on, the plaintiff attorney will be able to either assess the fraud, do additional discovery, or, drop the case completely. So in Michigan, it is long established that the failure to raise an affirmative defense as required by the Michigan court rules constitutes a waiver of that affirmative defense. Additionally, reliance on an exclusionary clause in an insurance policy is an affirmative defense. So if you are trying to say that the fraudulent concealment or misrepresentation language based on your policy is what gets you to void the policy, ultimately, you need to include it in the affirmative defense. Ultimately, in the Baker versus IDS case, the Court of Appeals reversed the trial court's decision and held that summary disposition was improperly granted to defendant as the defense of fraud was waived by IDS's failure to properly raise it as an affirmative defense. The Court of Appeals reasoned that IDS did not raise its reliance on the fraud exclusion in its affirmative defenses to either the original or the amended complaint, nor did it first raise it in the motion filed before filing a responsive pleading. In other words, in order to bar the plaintiff's claim for fraud, the defendants must have first indicated that the claim was barred. And for the claim to be barred as a prima facie case, you must raise it as an affirmative defense. The long and short of it is that if you have a fraudulent claim, you need to raise the affirmative defense as fraud if you have any intent for fraud, if you have any intention of filing any kind of Bahri motion down the line or trying to void the claim or rescind the policy ab initio. And of course, that goes back to longstanding Michigan law that is time and again issued by the Supreme Court and the Michigan Court of Appeals, indicating that any kind of exclusionary clause in an insurance policy is an affirmative defense that must be raised with responsive pleadings. Now, there are two cases that came down from the Michigan Court of Appeals pertaining to attorney fees, and that's the Bronson case and then the Spectrum Health Hospital case. Both of those were issued on March 27th of 2018. Essentially what happened in both cases is that the providers filed suit seeking the difference between what it billed for services and then the treatment provided to the injured parties and what the carrier paid. This is commonly known as balance billing. So these were balance bill suits that the hospitals were pursuing. Eventually, the Bronson case proceeded to trial and resulted in a directed verdict in favor of plaintiff on the reasonableness of the charges. The only question presented to the jury was about the reasonableness of charges, actually. But then Bronson filed a post-judgment motion for no-fault attorney fees and argued that Farm Bureau unreasonably refused to pay the entire claim. The lower courts actually agreed with the plaintiff and awarded Bronson statutory no-fault attorney fees. However, in Spectrum, the provider filed suit to recover the balance bills for services and treatment provided to the injured parties. At trial, the jury returned a verdict that Spectrum's charges were again reasonable. Spectrum again moved for attorney fees under 3148, and the lower court agreed and granted Spectrum's motion for no-fault attorney fees. On appeal, Both defendants, insurers Bronson and Spectrum, appealed the judgments and the rulings, including the award of no-fault attorney fees. And first and foremost, the argument was a covenant argument, that the providers first and foremost did not have standing to bring the suit, but more importantly, they certainly did not have standing to pursue any kind of post-judgment attorney fees. The argument there is that any agreement to assign a right of benefits payable in the future is void. The argument is that award of a no-fault attorney fees is a post-judgment future award, and assigning this ability, even if the assignment of rights is valid, should be prohibited. Further, under the No-Fault Act, no-fault fees are traditionally not considered a present benefit under the Act. Now, these cases kind of do muck up the water. They don't provide a definitive ruling as to whether or not Bronson and Spectrum were able to properly recover the attorney fees. Instead, the panel in the Court of Appeals reiterated that providers do not have an independent statutory right to a direct cause of action against insurers. Therefore, while the defendant insurers won on the issues relative to lack of standing and no-fault attorney fees, their cases were remanded back to the lower court for further proceedings. Essentially, the court, in a lot of words, was trying to give the plaintiffs an opportunity to fix their pleadings so that they could recover on these judgments. So we'll have to wait to see what happens with those, but it's likely that the trial court will enter some sort of order, and as indicated by the Court of Appeals. Now, the final case from the Court of Appeals update is Enriquez versus Everest National Insurance. In that case, the Court of Appeals confirmed Michigan's longstanding principles of contract law that in order to rescind a contract, one must repudiate the contract and restore the other party to the status quo as if the contract had never been performed. In other words, you need to put the person back in the position they would have been in had the contract never been formed. So in Michigan, to rescind a contract, it is not enough to merely terminate it, but you must rescind it and undo it from the very beginning. So one simply cannot release the other party from a further obligation. The entire contract must be annulled from the beginning, and you, as the person rescinding the contract, you're responsible for putting that person back in their position and making them whole. So in Enriquez, the plaintiffs filed suit against Everest after they were involved in a car accident. The lawsuit had several other parties, including intervening plaintiffs and various third-party defendants, but the key issues here pertain to the claimants as the insureds and the insurance company. During the course of litigation, Everest discovered that Enriquez made misrepresentations on her application for the insurance policy. Specifically, Enriquez listed only herself as a potential driver when she was living with her boyfriend and 15-year-old daughter, which is in direct contradiction of the policy language. Indeed, the policy language for Everest pertaining to this particular fraud indicates that all household members age 14 or older, including but not limited to spouses, roommates, children, family members, and wards, must be listed as potential drivers. 14 or older must be listed as a potential driver. The plaintiff in this case had a 15-year-old daughter that was not listed. Your total policy premium can be affected by this information is the specific language from the Everest policy. Furthermore, an applicant questionnaire within the application asked, have you identified on this application all members of your household who are the age of 14? Enriquez checked yes. So despite being specifically asked about whether or not she revealed or disclosed her 15-year-old daughter, she said that she did, which turned out to be untrue. So 6 days after the policy was issued, Enriquez and her daughter were involved in a car accident. After Everest did not pay benefits in a timely fashion, Enriquez and her daughter both filed suit for payment of first-party benefits. During the depositions, Enriquez admitted that she lived with her boyfriend and her 15-year-old daughter, whom she did not disclose to Everest. Based on these misrepresentations, Everest moved to rescind the policy and sent Enriquez a refund for the full premium paid. That goes back to making someone whole after you rescind the policy. Enriquez cashed the check, thereby accepting the rescission. Afterward, Everest filed a motion for summary disposition. However, the trial court denied Everest's motion on the basis that Enriquez could not speak English and that the applicant questionnaire did not allow the applicant to reply no when asked whether all potential drivers were listed. In an unpublished decision, the Court of Appeals reversed the trial court's decision and held that Enriquez acceptance of the return of consideration she paid toward the contract created a mutual agreement or a mutual assent to rescind the contract, thereby excusing all duties and rights flowing from the contract. So because they refunded her premiums and then she cashed the check for those premiums, that made it a done deal. So the endorsement and the cashing of a check represented the party's acceptance of the other party's terms to the contract and to the rescission. So the Court of Appeals reasoned that when Everest mailed the rescission notice and premium refund check to her attorney, it constituted a return of the consideration, restoring her to the status quo. So since the contract was legally rescinded, the claims against Everest were no longer valid. So this case particularly goes through, what is required in order to have a proper rescission that's going to allow you to dispose of an entire claim and any kind of claim that stems under the policy, for example, like her daughter's claim as a resident relative. So the rule here is that in order to rescind, you must restore the party to the status quo and put them in a place as if the contract had never been performed. By refunding the premiums, by sending her a rescission notice letter, Everest did everything that it was supposed to do in the handling of the claim to justify and validate this void ab initio concept. So once mailing all those things out and the plaintiff accepted and cashed the check, that completed the valid rescission, and she could no longer make a claim for benefits based upon her fraudulent misrepresentations. Those are the cases coming down from the Court of Appeals this month. We will continue to keep a lookout for the upcoming cases for the month of May and provide you with the May 2018 podcast. Each month we will feature a specific topic about any kind of trend in the first-party industry and provide you with an overview of key issues in first-party practice. I certainly welcome your questions. I'm sure Renee Townsend does as well. So if you have any questions on her reptile trial, feel free to give her a call or shoot her an email. Her contact information is there. In addition, if you have any topics that you would like us to discuss or address, please contact me. I'm always looking for topic ideas, and I welcome any kind of commentary or questions you may have. Thank you again for listening to Seacrest Wardle's Michigan PIP Monthly for the month of April.